title again?
The Counter Clerks of Justice Scalia. What does that mean? I'm about to tell you. Well, thank you very much, Brian. I'm certainly convinced, hope all of you are as well. I thought that I would start with a short story about the justice and my time with him. I was a law clerk for him in 2012, 2013, and given the nature of this conference and the nature of the center we're at, this is a story about food. So, imagine, if you will, about 2 or 3 weeks into the clerkship. My law clerks and I, my co-clerks and I, there were 4 of us, all of us had just started a few weeks ago. And it was traditional for the justice, who didn't usually eat lunch out of the office, but he liked his law clerks a lot. And so early in the year, what he liked to do is have a lunch after everybody had started. All of us would go out together, the 5 of you, so you could get to know each other a little bit. So you'd be working together for the rest of the year. And at the time, the justice's favorite pizza place in D.C. had closed about 10 years ago. And he never really found another place that he loved quite as much. Apparently, by the way, this place was a real dump, actually. But the justice had loved it, but anyway, it was closed. And he was on a book tour, and some random member of the television audience, seeing him on a cable television program, found out about this, emailed into Chambers, "I have a suggestion of a pizza place you should try, you're going to love it." And so the justice, who actually really enjoyed getting these sorts of messages from people, told his secretary, he said, "Why don't we take the law clerks there, to that place?" And she suggested it to us, and we looked at the website. I'm going to tell you some things about this pizza place that are going to horrify you. Right, as good Italian as this. Number 1, it had a giant inflatable Statue of Liberty out front. Number 2, you couldn't sit down. It was all counter service, right? So you couldn't sit down at a table, you had to order at the counter. And 3, most damningly, when we saw this, our sort of hearts just dropped, no wine, right? None. And this is a non-starter for Justice Scalia at lunchtime, at least when he's going to go out, okay? So we realized if we take this guy to his place, we're all going to get fired. We just met him, and so we made the suggestion of going someplace else. I said, there's a pizza place in my neighborhood. I think it's pretty good. I don't really know if it's up to his standards, but I go there all the time, and you can sit down, and there is wine. There's great Nero d'Avola. I've heard that that's like a Sicilian thing or something. I think he's going to love it. Okay. So we drive up there, and while we're in the van, I realize that it is an exceptionally long drive to my house, and we don't know this man, who we're all very intimidated by, all the time. It's a little difficult to make small talk, especially when he begins openly complaining about the length of the drive to the driver. Boy, this is a long way to go for pizza, Fernando. And I'm realizing that having suggested this is entirely on my shoulders. I'm starting to feel very uncomfortable. And he turns around and he asks me, he's like, "You said this is a good pizza place, right?" I said, "Yeah, it's pretty good." He said, "What kind of anchovies? Do they have anchovies?" I said, yeah, they have anchovies, I think. And he said, "Well, what kind of anchovies are they? Are they the white or the black anchovies?" And at this point, I'm like, I don't want to just admit I have no idea, because, I'm not really at that level with him yet. So I said, "Well, which is the kind that you like?" And he says, "I think he says the white anchovies." And I said, "Well, that's the kind they have." Figuring that if they don't have that kind, he'll probably just fire me and I can walk home since I'm in the neighborhood anyway, so why not really go all in? So we go in, we sit down, he orders the pizza. This place, by the way, could not be more thrilled. This is a really nice pizza place. And the fact that Justice Scalia is coming to their pizza place way up in the north of D.C., they're rolling out the red carpet big time. So we sit down, and the pizza comes, and he orders the anchovies, and the moment of truth arrives, and he looks at them and he says, "Now these are real anchovies." And I was like, "Well, of course, why would I mislead you?" And that's how the year began. So that's my story about Justice Scalia's connection to his Italian-Americanness, and that is the last I really have to say about that subject, because I've really come to talk to you about something a little bit different. So, as I said, I was a law clerk in 2012, 2013 for Justice Scalia, and when this comes up in a social setting, usually at a party, for example, I usually get about 2 reactions, and basically in this order. People say, "Wow, that's really cool," and I agree, and that's basically my reaction on it too. And then there's this pause, a very pregnant pause, and people lean over to me and they say, "You're not a Republican, are you?" And they say it, they get a sense of the tone. I want you to imagine asking somebody seated next to you at dinner if they have pink eye. Because you don't get the sense that they're asking like it's a good thing. And the answer is, no, I'm not, although I have to say that it has given me a great deal of sympathy for the so-called shy Tory problem, where conservatives are basically berated into hiding their identity as conservatives because everybody in every social setting that they're in berates them about it. So no, I'm not. I'm not any kind of Republican. I am, in fact, a liberal. And when I say this, they say, "Oh, so you were like the token liberal." And that's basically right, although typically people don't like to be described to their faces as tokens. But that is basically the term. The term that we would use was counterclerk, right? And this is basically the idea of this. Justice Scalia, as far as I'm aware, was unique in the following practice, which is that when he could find the right sort of person, he liked to have a person in chambers who was a political liberal rather than a political conservative. And he himself explained the purpose of this many times over the course of the years. The purpose of this was not actually to have a sort of root and branch opponent in chambers who disagreed with him about everything all the time. That would actually not be helpful in the context of trying to do one's job, nor would it be much fun for either him or that law clerk. The idea was that if you had a person who had politically liberal instincts, but shared a methodological agreement with him about how we do law, how do we do the interpretation of statutes, how do we do the interpretation of the Constitution, then it would help him not make mistakes in cases where he might otherwise do so. Because as he explained, one consequence of his method is that a good originalist or a good textualist should frequently find himself coming to results that he finds politically bitter, right? Because textualism and originalism, his telling, is not a conservative or a liberal philosophy. It's just a way we do law that affords respect to the original public meaning of these enactments. So he would actually like to brag. Whenever he got out on the lecture circuit, there were certain examples he loved to trot out of cases where he had had to swallow this bitter pill and do it. The flag burning case, for example, that was always his favorite, Texas v. Johnson. That's a 5-4 opinion, okay? This was not a cheap vote. If he had voted the other way, that statute would have been upheld. But he didn't. And he loved to tell how his wife was mad at him. Maureen was like humming, some great flag song that I can't remember the name of when he came down for breakfast that morning of oral argument. And his vote was necessary to the result. He was very proud of it, even though he also liked to brag that if it were up to him, he would throw these scruffy bearded hippies burning the flag in jail if he were king, he said. But he was not king. He liked to point out his example for an example is the vote he had in an EPA case involving the Clean Air Act and whether or not to consider cost in setting air quality standards, right? So the sort of politically conservative position in that litigation by the business groups is, well, of course you have to take cost into account. But the statute said nothing about that, and he wrote a decision called Whitman versus American Trucking that says, hey, it's not in the statute, right? Congress, if it had meant for you to consider costs, it would have said something about considering costs and setting the clean air standards. They didn't, and so you don't. He loved that example, and there were many such examples. So what he wanted was someone who was politically liberal but shared those methodological commitments to save him from making mistakes that he would regard as mistakes by his own lights. Right? Because a faint-hearted textualist, a faint-hearted originalist might want to look the other way in those difficult cases, he believed. And he wanted someone who could point out what he was doing to him and force him to reckon with that basic methodological commitment that he had made so he could keep doing the right thing. As I said, as far as I am aware, no other justice regularly has made it a practice to hire a law clerk who has that sort of particular characteristics, right? I'm not saying that other justices don't have mixes of people in their chambers, but he made a point of trying to find someone like that when he could. And my year, that was me. So, the other thing people, I think, usually want to know about this was, well, so what's the relationship like, right? And in general, the relationship is just about as warm as you could possibly imagine. And the thing that comes to mind that I think best illustrates this is when I was clerking, one of the justice's former law clerks, Rachel Barkow, who's a professor now at NYU and clerked for him about 10 years before me, was named to be a member of the United States Sentencing Commission. And the Sentencing Commission sets guidelines for federal judges in criminal cases for what the sentences should be. And for many, many years, the justice had derided this institution as blatantly unconstitutional. He referred to it as a junior varsity legislature at one point, and he was terribly offended by its existence and the fact that its recommendations were binding, for reasons he set out at length that I encourage you all to read. So I came in to tell him that one of his former law clerks was going to serve on this JV legislature. And he said, that unconstitutional commission? And then there was this pause, and he said, good for her. And that was pretty much the way he felt. Like the way that you might think about a member of your family, who you regard as hopelessly politically misguided, but is still a member of your family. He was happy for them, right? And it's worth noting, by the way, that he understood perfectly well that by giving this credential, a Supreme Court clerkship for a young lawyer really makes possible a lot of things in life that wouldn't otherwise be. It is an enormous honor, it is an enormous privilege, it's one of the biggest things that can happen to you in your young career. And he knew that he was credentialing young liberals who would use their prominence, who would use the positions that they had in their careers, who would use sort of really the platform that he was building for them to do things that he might find politically disagreeable. He understood that perfectly well. And he did it anyway because he thought it was important to him being a good judge and a good justice. And he liked us, at least most of us. Now, most of, I think, of us feel the same way. That's certainly how I feel. I feel about him like I feel about, my grandfather, right, who's as staunch a Republican as you can imagine, and is still very beloved to me, and has often taught me a thing or two. That's about the, that's about the sort of order of operations, right? Not everybody, to be sure, not everybody. And there are people out there who I won't even really bother to name who have used that platform because you can gain special prominence if you stand on that platform and then swing at the man who put you there, right? That is a way to really get attention for yourself. So you can become a very, very paid attention to person if you are willing to, as a former Justice Scalia clerk, get out there in public and eviscerate the man. I'm not even going to name those people because I regard that as so basically dishonorable that I don't want to give them any more attention than they already have. But there's actually one person who, after the justice died, wrote a very interesting article about his time with him. His name is Gil Seinfeld. He's a professor at the University of Michigan. And he had a far more thoughtful account that I want to tell you about because I think it has something interesting to say about the work of law clerks and how they do their jobs, especially in the capacity I've described. So, a little bit of background is necessary to understand the controversy at issue here. So, Professor Seinfeld was a law clerk during the 2002-2003 term. And at the end of that term, there was a case decided that is destined to be Exhibit A in the justice's for critics of the justice for the rest of time. It's called Lawrence v. Texas. Okay? The question in Lawrence v. Texas was whether or not Texas could prohibit criminally people of the same sex from having sex. Okay? It had this law in the books, and the question was, is that constitutional or not? The court said it was not. And Justice Scalia wrote a dissent saying that he did not agree with that. In other words, he would have upheld the law and would have said if states want to criminalize this, that's up to them. They are neither required nor prohibited from doing so. And what's interesting about this is that Professor Seinfeld was a law clerk then, and he says in his article that he begged off of working off that case at all. He just didn't want anything to do with it. He didn't want to help improve the prose, he said. He didn't want to help him deliberate. He's just like, can you just leave me out of this one? He actually mentions it as a flattering anecdote because he says the justice excused him from having to work in this case, and he said he never felt any bad feelings about it at all. But, Professor Seinfeld says, the opinion still bothers him. And to give you a sense of why, I think it's important to actually read a couple of the passages that Seinfeld criticizes, because I think there's something interesting to be learned here. So, let's see here. I actually got the opinion right here due to the magic of the internet. And he says, in particular, the closing section of the opinion begins this way, and this is what people quote when they want to criticize the justice. He says, today's decision is the product of a court, which is the product of a law profession culture that has largely signed on to the so-called homosexual agenda, by which I mean the agenda promoted by some homosexual activists directed at eliminating the moral opprobrium that is traditionally attached to homosexual conduct. Now, you can hear, you heard it as soon as I said it, the fat, juicy target in the middle of that sentence. It is the term homosexual agenda, which even though he goes on to explain what he means, that context is never quoted and never will be. There are various other portions of this opinion that have similar passages that are basically rhetorical clunkers, right? And Seinfeld says he didn't want anything to do with this, he didn't want to help him improve the prose. And the reason I think this is interesting is because, in a sense, there's one way of viewing this, and I don't mean to criticize anybody's decisions, by the way. I can't say that I would have made the same decision or a different one. I wasn't there. But what I do know is that the justice's opinions about the legal protections for same-sex relationships were capable of being expressed in a different way. The same substantively identical positions were capable of being expressed in very, very different ways. And the reason I know that is because about a decade later, he wrote another dissent from another opinion called the United States versus Windsor, which was about the constitutionality of the Federal Defense of Marriage Act, which said that for federal law purposes, only a marriage between a man and a woman would be recognized for federal law. The question is that a constitutional law or not? The court said no. Again, he wrote a dissent in which he said yes. And I just want you to listen to the somewhat different tone that he says. He says, at the concluding section of that dissent, he said, and I quote, the same-sex marriage debate, quote, has inspired passion by good people on all sides, It has prompted plebiscites, legislation, persuasion, and loud voices, in other words, democracy. He strongly disagreed with the idea that the, quote, story is black and white, hate your neighbor or come along with us. And he spoke, admiringly, of our fellow human beings, our fellow citizens who are homosexual, and he was very upset that the majority believed that Congress had acted with the purpose to demean and degrade or humiliate gay people, right? And his stated regret was not that the proponents of same-sex marriage had won, but that the court had, quote, not let the people decide. Now, as I said, there's not a substantive difference in those positions. In both cases, what he's saying is that the democratic process ought to be allowed to sort of run its course, and this is a subject that is committed to the debate among the people themselves, right? But there is a big difference in tone there, and I have to wonder, what if somebody in Professor Seinfeld's position had wanted to improve the prose? He says the opinion still bothers him, and it bothers a lot of people. Those passages that ring badly in your ear, ring badly to mine, especially because I admire the man so much. And I just have to wonder if Seinfeld had somewhat missed the point of a justice who had said, I'm going to make mistakes, and I want people around who will stop me from making those mistakes. The purpose of my law clerks that I am bringing in here is to tell me things like, you know, Justice, not for nothing, but if you open with the term homosexual agenda, that's where 75% of people are going to stop reading, and they're not going to get the point, the argument you're trying to make, right? Would that have been effective? I have no way of knowing that, obviously. The justice was not a man who was liable to be intimidated by his law clerks into doing anything he did not want to do. But I do have to say that my vision of the role of the counter clerk in a situation like that is to sort of act like the catcher in the rye, to protect, as one of the speakers said earlier, your judge from doing something that later they will come to regret. And the thing is, he knew that sometimes he made mistakes. In our interview, the first thing he said to me when we sat down, the first substantive thing was, why don't you tell me an opinion that I've written in the last couple of years that you disagree with, so we can argue about it a little bit? And that was a bit of an intimidating request, certainly. But it illustrated the way that he went about his job. He wanted debate in chambers. He wanted someone who would stand up to him. And he knew to get the job, you had to be willing to identify, look, on such and such case, on such and such occasion, you were completely wrong. One of the standard interview questions in the interview from the law clerks, what is the most wrong opinion that the justice has ever written? So he understood and built an institution that would enable him to sort of hear these things from his law clerks. And I just have to wonder that in that situation, begging off was really the right thing to do. So now, of course, there will not be any more counter clerks for Justice Scalia, because there will be no more clerks for Justice Scalia, unfortunately. I do have to wonder, though, whether this practice would be a fruitful question at the confirmation hearings. I would be interested to know whether whomever will replace the justice is open to the idea of having a person in chambers who shares methodological similarities but different political commitments. I'm not saying it should be a requirement of the job, but I've never heard of anyone else doing it, and I just wonder if that practice isn't a healthy one, that we should be encouraging in the democracy. It's not such a bad thing sometimes to have these irritants around like me. It can occasionally prove quite useful, and you can ignore them the rest of the time. It's not that bad. So I think it's fair to ask that of our judges. I think it's fair to ask it of us in our own lives. Certainly the mission of the university, as was described earlier, seems to embrace that. So although there will be no more of us counter clerks, neither will there be, as Brian I think has vividly illustrated, any liberals who are free of the influence of the justice. Because when they go through law school, when they're marching through their case books, they will see the justice on the page, and they will be invited to pick an opinion that they disagree with so that they can argue about it. Thank you very much.
Thank you.